G'day everyone and welcome to video 4.2.11 for the Legal Studies guy. Third last video, I suppose probably the last real topic as well. So almost there. Our quote today from Norman Vincent Peale is change your thoughts and you change the world. And this is the whole idea that I suppose positivity is, a frame of mind. It's a mindset. It's a choice that you can make to view the world in a positive light. And this whole idea is you do have the choice with how you perceive the things around you, and if you can change those thoughts, you can change the world. So I suppose a bit of a goal today is to look on the world with a bit more positivity. Our key knowledge point today is 4.2.11, and we're looking at the role of one parliamentary committee or one royal commission recommending law reform. Now, the key word here is the or, this idea that they cannot ask us a question just about royal commissions on the exam. They would have to ask us a question that then says, using royal commission or parliamentary committees, answer this. Now, this is very much, we're talking the role of one. We are going to do royal commissions. Sorry, I should tick that off. So we're talking the role of one royal commission recommending law reform. Now, what I'm actually going to do in this set of slides is just talk about royal commissions in general. What is a royal commission? And then in the next set of slides, which is about a recommendation for law reform from a royal commission, we're going to look specifically at one royal commission in a lot more detail. So this is just going to be the general intro. What is a royal commission? The next one's going to have that specific details of a royal commission that will then build our understanding across the 2 dot points. As we know by looking at the VLRC with our last couple of sets of slides, by the end of this we're going to evaluate the ability of the VLRC and royal commissions to influence a change in the law using those recent examples. So we'll be able to say whether the Royal Commission is effective or not effective at influencing legal change. So what is a Royal Commission and how does it influence law reform? Well, I go straight to this quote from the Australian government website. Pretty straightforward and to the point. In the Australian system of government, Royal Commissions are the highest form of inquiry on matters of public importance. Basically, the most important matters that need further investigation, that affect basically the entire populace. A royal commission might be called to actually investigate and inquire into what's happened. It's about finding out what's happened. And this is effectively what a royal commission is. It's an advisory body appointed by the government to complete a public inquiry into issues of great importance. Definitely this statement here, which is from an article that I'll link you at the end, is the idea that royal commissions are viewed as an institution of last resort. Okay? If there's no other answer to try and, I suppose, get to the bottom of something, we'll call a royal commission. Things like the example that we'll look at in the next set of slides is a royal commission into institutional responses to child abuse, child sexual abuse. So Royal Commission that ran for 5 years and looking at basically all of this historical stuff around religious institutions, out-of-home care facilities, so orphanages, etc., schools, and both incidents of child sexual abuse in those settings, but also how those institutions had failed to respond to those allegations through cover-ups, etc. So the Royal Commission investigated all of this, all these different examples of this across multiple years, multiple institutions. Another example of a royal commission is the Victorian government. So states can call their own royal commissions as well as the federal government calling national ones. The Victorian government called a royal commission into domestic violence effectively, so then can investigate the issue in full and make recommendations. Another national one that's running at the moment is the Royal Commission into the banking sector and the finance sector and some of the mismanagement from basically the major banks of Australia. So this whole idea that if we get an issue of great importance, we can basically ask a Royal Commission to inquire into it and figure out what the hell's going on. They will utilise a range of measures to fully investigate an issue, and these measures include things like community consultations, roundtable discussions. They might employ people to do research, and they'll hold hearings. So public hearings, private hearings. The Banking Royal Commission at the moment has had some really interesting public hearings. And at these public hearings, you can actually compel witnesses to attend. So you can force people to attend, and it's actually an offence to not attend. So the Banking Royal Commission's been really good for some of these public hearings where bank executives, so people who run the big banks like NAB, ANZ, etc., have been forced to attend and give evidence and been questioned on the stand, basically about what those banks had done to try and stop people being ripped off, which turns out, strangely enough, has been not much at all. So Royal Commissions have this immense power to actually compel people to attend and therefore really delve into an issue and get to the bottom of it, which is a pretty special feature of them. Definitely something the Victorian Law Reform Commission doesn't have. They'll also accept written submissions like the Victorian Law Reform Commission, and they'll use issues papers, so they'll present issues papers or consultation papers to help frame these. So the idea of, hey, this is one of the issues we want to look at. You can respond to this issue specifically with a public submission if you want. When they do compel people to attend and hold public hearings, these are similar to courts in their rules of evidence and procedure. So you'll be questioned like you would be in a courtroom. And as I said, you can be charged with an offence if you fail to comply. At the end of this, the Royal Commission will write a final report. And this final report will include all of their findings, all of the information they've gathered, all of the research they've done. We look at Child Sexual Abuse Royal Commission in the next set of slides, and we find that their final report was 17 volumes with over 1,000 pages. And they basically include over 400 recommendations for changes to the law or changes to processes. And we're obviously going to focus on law reform changes to the law. So Royal Commission, heaps of powers, gets heaps of information from hearings, from roundtable discussions, from community consultations, can force people to come and give evidence and be witnesses at public hearings. And once they've used all of these measures, they'll write up a report that fully covers the issue and includes recommendations for change. This is Section 1A of the Royal Commissions Act of 1902, which is the law that enables Royal Commissions, and it is a load of legalese. It's hard to read, but if you read through this, what we're going to focus on is really this second section here, because this first section is just a little bit of legal wank almost. But the Governor General may, by what we call letters patent, which is basically the document that starts a Royal Commission, issue such commissions directed to such persons or persons as he or she thinks fit. So basically they can pick whoever they want, okay, and authorising him or her or them or any of them to make inquiry into and report upon any matter specified in the letters patent, which relates to or is connected with the peace, order and good government of the Commonwealth. So effectively, the Governor-General, and we know the Governor-General acts on the advice of Prime Minister and Cabinet. So it's effectively Prime Minister and Cabinet, but they can pick someone or a group of people to inquire into any issue connected to the peace, order and good governance of the Commonwealth. So basically anything at all. And the Royal Commissions Act goes on to give them these powers to question witnesses and give them these powers to force people to comply. So a Royal Commission is very, very, very important and very, very, very powerful as mandated by this Act from 1902. This isn't a clear cut and dry process, but once the referral comes from the Crown's representative or from the government effectively, which includes the terms of references like a VLRC referral, which will have guidelines, time limits, etc. Once the Governor-General gives these to the commissioners, so who they choose to investigate, these two will occur, and I mean, they kind of work at the same time, these two steps of the process, but there's this whole idea that once they're authorised to investigate, the commissioners will, employ a staff. That staff will do some initial research, figure out what the main issues are, develop some issues papers that will then allow people to make public submissions in line with these. And then once they receive these public submissions, or while they're receiving them, they'll go out and they'll hold their public hearings. Okay? They'll question witnesses. They'll get lawyers in to do the questioning for them, who are employed by the Royal Commission. Some witnesses will attend voluntarily. They'll also hold private sessions, expert roundtables, community consultations, etc. Always responding to these issues that are identified here. Okay? And as new issues come up, they might write new issues papers, and they might go through these two steps again. Particularly, the Child Abuse Royal Commission was due to finish in 2015 and actually got extended to 2017 because of how broad it became once it was started. So they're really flexible Royal Commissions. Once they start, they may go down a path that they weren't expected to, and they may find out or investigate things that they weren't originally intending to. So this whole idea of there's the referral, they identify the key issues, they have hearing submissions based on them, and then if need be, they identify more issues. And once this is done, and they've gone through all of this, the Royal Commission writes their report. And as we know, their report will include recommendations for law reform. And just like the VLRC, then the government responds, and Parliament gets to decide the extent to which they will accept the recommendations. Again, there's no obligation to. They can have the Royal Commission spend 5 years investigating something, and at the end of it say, no, we don't care. Okay? It's probably unlikely that they will when we look at the strengths and weaknesses of a Royal Commission, but ultimately, no obligation to act. So, let's evaluate the ability of law reform bodies to influence a change in the law. So let's evaluate the ability of a Royal Commission to influence legal change, and we're going to do it in response to this question again. So there are bodies that are more effective than the VLRC in influencing law reform, with reference to either parliamentary committees or Royal Commissions. So we know that we can scrub out this, and the question is just, with reference to Royal Commissions, discuss the extent to which you agree with this statement. So we're going to have to look at the strengths of the VLRC and the strengths of Royal Commissions, and the weaknesses of the VLRC and the weaknesses of Royal Commissions, to decide whether we agree that Royal Commissions are more effective than the VLRC. So in terms of Royal Commissions are really effective in the scope that they have, their ability to investigate a matter to its absolute fullest, okay? And to be flexible as they do that, because they basically have power to look at the matter in its complete fullness. Okay? They're really publicly respected. Royal Commissions are very publicly respected. We love a Royal Commission in Australia, and we really listen to the recommendations they make. As a result, Parliament's probably going to want to follow through on the recommendations they make, or else they're going to lose public support. And we know that then factors that affect the ability of Parliament to make law is the idea of representative democracy, that if they don't make laws we like, we'll vote them out. So the fact that Royal Commissions are very publicly respected is definitely makes them effective in influencing law reform. And they do attract huge amounts of publicity. The banking sector Royal Commission has been, really regularly front page of the paper. So lots of public awareness around the issue. Therefore, public become invested in change. Right now in Australia, the public is really, really invested in Parliament legislating to limit the control or influence of the big banks based on what's coming out in this Royal Commission. So that makes them more effective at influencing law reform because, again, they get the public on board. But much like with the VLRC, Parliament doesn't have to act, no obligation. They're not effective at influencing law reform because they're actually unlikely to occur. So this is kind of like using the courts to influence law reform. Royal Commissions are pretty rare. They're not that common. There've only been, I think, 2 federal Royal Commissions in the last 10 years or something similar. And this is because they tend to create some negative sentiment towards the government who called them. Right now, the Liberal government who called the Royal Commission into the banking sector is copping a heap of heat because they've basically been supporters of the banking sector for so long and made legislation that makes it easier for those banks to make profit. So all of a sudden, the Liberal Party's under heat based on the Royal Commission that they called. So it makes Royal Commissions not as effective because they're less likely to occur because governments don't want to call them. And plus, they're just expensive. Time consuming. The Child Abuse Royal Commission, 5 years. Yep, I don't think anyone's ever going to argue that that wasn't a worthwhile endeavour. But again, it just means they're less likely to be called for. We're more likely to use things like parliamentary committees than a Royal Commission, and therefore Royal Commissions are limited in their ability to influence law reform because they just don't get the chance to. I've included some links here. This is the article that I mentioned earlier that I got a quote on about Royal Commissions being the institute of last resort. I would absolutely recommend having a read of it. The conversation explains stuff in a really understandable way. And then you've got the official Royal Commission's website that has basically a list of all the Royal Commissions ever and some details about their powers and so on. Look, as I said, even though we are looking at the role of, scrub this out, the role of one Royal Commission recommending law reform, we're going to look at the example in detail in the next slides. We were just unpacking what a Royal Commission is and starting to look at the strengths and weaknesses. So hopefully you can tell us what is a Royal Commission and how does it influence law reform. Another video for the Legal Studies Guide done and dusted. 2 more to go. Happy studying. Do all the liking and subscribing and let me know if you've got any feedback.